Today we talk about drink driving, how to represent yourself in court, and the range of penalties available for the court. There are generally three types of main drink driving charges. The first is the low range from 0.05 to 0.08. There's the mid-range drink driving, 0.08 to 0.15, and there's a high range drink driving, 0.15 and above. When you are charged with a drink driving matter, the police will give you a yellow court attendance notice slip. That court attendance notice will have the court date. When you attend court on that first court date, you have one of two options. The first option is to plead guilty to the charge. The other option is to plead not guilty to the charge. If you plead not guilty to the charge, you need a possible defence. And an example of a defence of pleading not guilty to a mid-range drink driving charge of, for example, 0.08 reading would be where you have your last few drinks and 5 minutes later you are pulled over by the police. 5 minutes later, when you're pulled over by the police officer is going to do what's called a random breath test, and that's most likely because of the residue in your mouth from having consumed the few drinks 5 minutes ago is going to give a positive reading. In which case, the police is going to take you back to the police station, which may take about half an hour. By that stage, the alcohol that you consumed at the time of just before you drove your vehicle and got pulled over, was still sitting in your stomach. But by this time you go to the police station, the alcohol that was sitting in your stomach may well have passed into your bloodstream. By that stage, you will most likely give a higher reading. And for example, if you give a reading of 0.08 at the police station, you may well be under 0.08, in which case it brings you down to the low range drink driving charge, which does not carry a jail term. Mid-range drink driving does carry a jail term, so it may be very beneficial to obtain what's called a pharmacological report. The other option you have on the first court date is to plead guilty to the charge. If you plead guilty on the first court date, you get what's called a 25% utilitarian value discount of the punishment of what you would otherwise have gotten had you pleaded not guilty and got found guilty afterwards. In other words, you will be punished more severely if you plead not guilty and are found guilty later. Now, if you plead guilty to the charge, it is always beneficial to obtain 3 to 4 good character references. What you need to include in these references will depend on your particular circumstances. But what I usually do is give a reference guide, which includes what comments should be made on the reference, what comments should not be made on the reference, and the format that the reference needs to be in. The other reason, the other way to prepare for it is, in addition to the references, is to participate in what's called the Traffic Offenders Program. This program goes for a period of 6 to 7 weeks, in which case, on the first court date, you will need to adjourn your proceedings for a period of about 8 weeks, in order for you to come back before the court, having completed the Traffic Offenders Program and having prepared and ready your 3 to 4 good character references. On the sentence date, having done the Traffic Offenders Program and having tendered the good character references to the court then wants to hear submissions from you. The court has a number of things that it takes into consideration when sentencing you. Now, the court firstly looks at the range of penalties available. For mid-range drink driving, for example, the court must look at the range of penalties available. They include, from most serious to least serious, full-time jail is the most serious of those penalties available to the court. Coming down from that ladder is home detention. Coming further down from that ladder is what's called an intensive correction order. The intensive correction order may require you to undertake counselling if that's adequate in the circumstances. It may also require you to do some community service work. Climbing further down from that ladder is an option for the court to impose what's called a Section 12 suspended sentence. So the court there will impose a sentence for a particular period of time, but it will suspend that period of time, so you do not actually go to jail. Climbing further down from that ladder is a community service order. The court may impose a community service order for a number of hours, and you will have to complete those hours. Climbing further down from that ladder is what's called a Section 9 Good Behaviour Bond. This may be a good behaviour bond period for up to 2 years. It could be 1 year. It's at the court's discretion. If you breach that good behaviour bond period, you will see yourself before the court and resentenced on that same matter. Now, the range of penalties I've discussed so far are all criminal convictions, which means you will obtain a criminal record from them. Climbing further down from that ladder is what's called a Section 10. The relevant legislation is the Crime Sentencing Procedure Act. Now, Section 10 means that you do not obtain a criminal record, you do not lose demerit points, and you do not receive a fine. So in effect, you continue driving. You're still eligible to drive. It's very difficult to get a Section 10, and in order to obtain a Section 10, the court looks at a number of things. If I can just go into those number of factors the court looks at, the court will be looking at the length of journey travelled. The court will look at whether or not anyone else was in the vehicle with you. The court will look at the nature of your employment, your need for a licence. Now, you really need to get across to the court whether or not you have a need for a licence, and the best way to do that is to obtain a good character reference from your employer to confirm that your licence is your livelihood, the need for your licence, how often you're on the road, the reason why you need it, and whether you will lose your job as a result of losing your licence. That's very important. The other things the court looks at is the inconvenience or the loss suffered to other people apart from yourself as a result of you losing your licence. The court also looks at your traffic record. If you have a prior drink driving matter, the court will look at how long ago it was. The court will look at whether it's a low range, mid range or a high range drink driving charge that you were convicted for. If you've already received a Section 10 before, it makes it more difficult to obtain again, but it's not impossible to do. The court will also look at whether or not you did anything to bring your attention to the police at the time of driving. If you did, it's considered an aggravating factor which will go against you. Those are the factors the court generally looks at when considering which penalty is appropriate to you, to your particular circumstances, but you really need to get across to the court and communicate those factors that are relevant to you, your need for a licence, the nature of your job, the inconvenience that may be suffered on other people if you lose your job, and the fact that you've done the traffic offenders program will also greatly assist you.